You are watching PR English Shorthand Dictations YouTube channel.
This is English Shorthand dictation number 389 and the dictation speed is 120 words per minute. Ready? Start. We have heard the learned counsel for the appellant and the learned counsel for the respondent for the insurer. The controversy in the present case pertains to the factum of repudiation of the insurance claim of the complainant on the ground of the material suppression of information regarding the previous policies allegedly held by the insured deceased while taking the life insurance policy from the opposite party. The learned counsel for the appellant submitted that the insurance company has not proved that appellant's father had any other insurance policy while taking the insurance policy from the opposite party. Thus, there has been no material suppression of fact in the application form with respect to holding any previous policy by the insured or his family members. It was further submitted by the appellant that the NCDRC was incorrect in upholding the repudiation of claim in the absence of an iota of documentary evidence on record to support the contention that the insured deceased had suppressed any fact under clause 6 of the proposal form about the previous policies issued by other insurers. The respondent has merely alleged the fact of multiple insurance policies of the insured deceased through their affidavit of evidence but had not discharged their burden of proof by leading any documentary evidence to support their allegation. The learned counsel for the respondent has supported the judgment of the NCDRC and has further contended that the insured deceased had taken 15 other insurance policies worth Rs 71,000 prior to the issuance of the subject policies by them. These policies were not disclosed in the proposal forms, and had the respondent been aware about these other insurance policies with other insurance companies and the existing risk cover at the time of assessment of risk under the subject policies, they would have certainly not issued the subject policies to the insured deceased. Thus, the insured deceased has suppressed the material fact and the claim has been rightly repudiated on this ground alone. The learned counsel for the respondent further submitted that the policy of life insurance is based upon the principle of utmost good faith. When a specific fact is asked for in the proposal form, an assured is under a solemn obligation to make a true and full disclosure of the information on the subject which is within the best of his knowledge. In the present case as well, the insured deceased was under the obligation to make complete and honest disclosure of all the facts and materials at the time of filling of the proposal form. The failure to do so shows the mala fide intention on the part of the insured deceased and renders the policy invalid and inoperative. Having heard the learned counsel for the respective parties, the point that arises for consideration before this court in the present civil appeal is whether the respondent herein was correct in repudiating the claim of the appellant on the ground of suppression of material information pertaining to the existing policies with other insurers. In order to answer the aforesaid question, it would be useful to recapitulate the relevant provisions of the law of insurance and evidence vis-a-vis burden of proof and the method of discharging that burden of proof to prove an alleged fact, which is suppression of a material fact while seeking an insurance policy from an insurer. The repudiation of an insurance claim is largely governed by Section 45 of the Insurance Act 1938. Section 45 is a special provision of law which bars the calling in question of an insurance policy beyond expiry of the stipulated period, except in a few circumstances that have to be proved by the insurer. Since the present case deals with a policy and its repudiation before the 2014 amendment to Section 45 of the Insurance Act, the pre amendment time period of 2 years would be applicable to the case. As per the aforesaid language and interpretation of Section 45, the insurer cannot question the policy after the expiry of the time period, and if it does, then the burden rests on the insurer to establish materiality of the fact suppressed and the knowledge of the insured about such suppression, so that the repudiation of the claim could be justified by the insurer. In the present case, the onus was on the insurer to show that the insured had fraudulently given false information and the said information was related to a material fact. The second aspect of the controversy would be dealt with first. For a better appreciation of the controversy, it would be important to analyze the principle of utmost good faith that governs the insurance contracts. It may also be observed that insurance contracts are special contracts based on the general principles of full disclosure, in as much as a person seeking insurance is bound to disclose all material facts relating to the risk involved. Law demands a higher standard of good faith in matters of insurance contracts. The plea of utmost good faith has also been taken by the respondent for contending that the insured deceased had a duty to disclose the details of the previous policies, as the same was sought in the application form. However, the insured failed in his duty to correctly answer the question about his previous policies. Just as the insured has a duty to disclose all material facts, the insurer must also inform the insured about the terms and conditions of the policy that is going to be issued to him and must strictly conform to the statements in the proposal form or prospectus or those made through his agents. Thus, the principle of utmost good faith imposes meaningful reciprocal duties owed by the insured to the insurer and vice versa. This inherent duty of disclosure was a common law duty of good faith, originally founded in equity but has later been statutorily recognized as noted above. It is also open to the parties entering into a contract to extend the duty or restrict it by the terms of the contract. The duty of the insured to observe utmost good faith is enforced by requiring him to respond to a proposal form which is so framed to seek all relevant information to be incorporated in the policy and to make it the basis of a contract. The contractual duty so imposed is that any suppression or falsity in the statements in the proposal form would result in a breach of duty of good faith and would render the policy invalid and consequently repudiate it at the instance of the insurer. The basic test hinges on whether the mind of a prudent insurer would be affected, either in deciding whether to take the risk at all or in fixing the premium by knowledge of a particular fact if it had been disclosed. Therefore, the fact must be one affecting the risk. If it has no bearing on the risk, it need not be disclosed, and if it would do no more than causing insurers to make inquiries and delaying issue of the insurance, it is not material if the result of the inquiries would have no effect on a prudent insurer.